The following is a paid program. Advice and opinions expressed during this program are solely that of Melick Law, not WBEV or Good Karma Brands.
Well, if I could walk on water.
And good morning. It is 11:11 here at 95.3 WBEV and also Daily Dodge TV. I am Wade Bates, sitting in for Justin Wilski today, as it's the Melick Law Show. Rob Melick here with us this morning. Hello, sir. How are you?
Good, Wade. How are you?
Good. Weather's cold outside, but, baseball's in the air. I know you're a big baseball guy. Are you excited?
Yeah, pitchers and catchers reporting here this week, so looking forward to that.
Our first game on WBEV is Saturday.
Oh, wow.
Brewers and Reds.
I'm looking forward to it. I got my
it is.
MLB package ready to go, so I can't
now,
wait.
Being the Brewers fan that you are, do you have confidence again that they'll just find a way to win between 87 and 95 games again this year?
I wish I could, but I don't see it. I'll be honest with you. I don't see it happening this year. I see them as more of a 500 team, but, you get health, you get some guys stepping up, who knows, but they lost a lot of players. Is Yelich going to be healthy? There's a lot of question marks there. But
you saw the same thing last year. How much confidence did you have last year?
Not very much. I had a little more than I have this year, though.
Okay.
It's just one of those things where it's really it always comes down to health and comes down to the rotation. So,
and do you know you may not have confidence in the Brewers, Rob?
Yeah.
But we have confidence in Melick Law to make sure your future is taken care of and people are ready if something would happen to maybe get through a tough time in a reasonable time and feeling good about themselves.
Well, that's an excellent segue, Wade. Yes, I would like to think that we have confidence in our services here from an estate planning standpoint because we can control those, right?
Yes.
We can't control whether a pitcher stays healthy. We can't control whether a hitter decides to be able to hit the ball the opposite field. We can't control that as fans. But from an estate planning perspective, I can help with that. No matter what your estate planning needs are, again, it's never a one-size-fits-all situation, so I do offer free initial consultations, whether it's reviewing existing documents that you have to make sure they're still adequate or starting from scratch. I can help people in either situation. Always a free initial consultation for most people in the listening and viewing audience. It would be the Beaver Dam office. Sandy and Matt let me use their office over at Heritage Mall, but I do also have office locations in Saukville, Germantown, and West Bend, and I do also offer in-person, in-home visits as well as virtual visits, Zoom, phone call, whatever the case is. Again, my goal, Wade, is to make this process as easy and as convenient as possible for people because I get it. People don't want to meet with an estate planning attorney. They don't want to think about their own mortality, but at the same time, it's important because it's something that we're all going to have to deal with at some point in time.
Yeah, and realistically, and I'm the first to admit, and I'm going to have an appointment with you sooner than later, but you keep kicking the can down the road. Eventually, you may miss that can and something may happen. And if you have the opportunity, make sure, you have the initial consultation, get the ball rolling. We always talk whether you're 18 years old, you're 25, you're 35, you're 50 like me, or even if I had a gentleman call the station a couple weeks ago looking to get in contact with you because he was like 68. And he says, I've been kicking the can down the road here and Rob talk every month. And I just haven't done it. And so it's a case of, get the ball rolling because not only yourself, if something happens to you, but also it's the people around you that you love. By taking care of this stuff, you can make it less stressful on them and kind of things are in place, right?
Absolutely. When it comes to estate planning, yes, giving yourself the peace of mind, but actually doing it as a way to relieve the burden from your loved ones is an even more important reason to do it. So that's most people's motivation behind getting an estate plan in place. I want to make it as easy as possible for my kids when I die. I hear that all the time, and that is a very constructive way of looking at estate planning because, yes, sure, as the creators of the document, you get to enjoy some benefits, but it's really to make things easier when this inevitable event does occur. Because you're right, it is never too late to do an estate plan until it's too late to do an estate plan. And, the obvious sign of it being too late is your own passing, right? Obviously, if you're deceased, you can't create an estate plan. But also incapacity. That happens a lot, too. As people get older, Alzheimer's, dementia, all these other things that could potentially come into play. Well, if you don't have capacity, if you don't have the mental ability to understand information, receive and process that information, you can't legally execute estate planning documents. So it's more than just before you pass away, it's before you lose capacity. And that incapacitating event could be a temporary one. Someone could be in a car accident and in a coma for 3 weeks. Well, during those 3 weeks, medical decisions need to be made, financial decisions need to be made. So if someone is younger and involved in that kind of car accident or sudden fall or whatever the case is, and they lose capacity for that period of time, Well, if we don't have that capacity, then we can't execute those documents. So planning ahead and making sure that these events that might occur, which is incapacity, or death that will occur, are accounted for, and that we have appropriate documents in place to nominate the people we want making those decisions.
Sure. And okay, what's the medical? What's the official term for the medical? The medical paperwork you need for somebody to be able to make those decisions for you. If you do end up in the ER, or maybe you have a routine surgery. I'm 50. What if I have a colonoscopy and something happens? With the anesthesia or something. Somebody's got to be able to make a decision. What is that official term?
Yeah, that's a healthcare power of attorney.
Yeah, healthcare power of attorney.
Right, and drawing a distinction there between a colonoscopy and everything else. When you go in for a colonoscopy, you know it's going to occur, right? You have it scheduled, everything else. So typically, you can sign some paperwork at the time when you're lucid and have capacity, saying, "I want this information to be communicated." That's great. The problem is if you're involved in that car accident,
on your way to colonoscopy.
Right, on the way to the colonoscopy, or if you have a stroke, whatever the case is, that's unexpected, and you lack the ability to make those decisions. So, and again, we just don't know what's going to happen. I've always joked around before. I think I've mentioned on the last show here that if for whatever reason this law thing doesn't work out, and it's been great so far, I don't anticipate it going anywhere. I love what I do for a living, but probably what I would do is I would be a sabermetrician. Are you familiar with what a sabermetrician is?
Enlighten me.
Yeah, so it's a pretty unique career field, and it ties into two things that I love: baseball and mathematics.
Okay.
Sabermetricians are hired by Major League Baseball teams and by other organizations to analyze baseball statistics. So, figuring out, okay, if this batter comes up against a left-handed pitcher, what is the likeliest outcomes? Where do we pitch left-handed hitters? Where do we, if we want to get a guy to ground into a double play, where's the best pitch and where is the best location for that pitch? Sabermetricians analyze this data. So I like numbers. I like baseball. Well, when it comes to baseball and numbers, it's pretty straightforward. But when it comes to estate planning, the number I use oftentimes is it's greater than zero. Yes. For anyone in this listening audience, right, the likelihood that you're going to have a stroke is unknown, but it's greater than zero. And because it's greater than zero, it's an event that we should at least be aware of, and because we do have documents in place that allow us to be able to be in that situation. How many people in this listening audience are ever going to be in a car accident during their lifetime where they will lose capacity? I have no idea, but I know it's greater than zero. And that's why we plan. That's why we have these documents in place, because, again, if it's 1 in 100 and you gather 100 people in a room, you don't know which of the 100 you're going to be. There are things that make it higher or lower likelihoods. For instance, if you only drive a car 100 miles a week versus 3,000 miles a week, well, sure, the likelihood of being in an accident if you drive 3,000 miles a week is higher than 100, but it doesn't make the person who drives its 100 0% either. So these are all things that I try to impress upon prospective clients, listeners, things like that, to make sure that we have these events in place, and we know that there are documents that will enable us to be able to nominate people to make those decisions if we fall into the unfortunate group of people who are subject to those.
So you talk about the medical power of attorney and that. So it's basically that person. Say if you don't have one, you said, and all of a sudden something happens, you have a heart stroke, you have a car accident, then it's obviously you may have a spouse that's there with you, but and they can give their input in some capacity, or is it all medical staff? Because I know they ask you a lot of times if you are visiting a doctor, say for some sort of a procedure, do you have a medical power of attorney?
Almost every physician asks that question when you have a physical or getting blood work. Here's the issue. There's this thing out there called HIPAA that most people are generally familiar with. Health Insurance Portability and Accountability Act determines when and under what circumstances medical providers can share your information. They can't share it without your consent. So that spouse coming in, that spouse has no authority without a power of attorney. Here's the other example I'll give in that sense. How many people in this country right now are married, for lack of a better phrase, against their will or against their better judgment? Maybe they are together for religious reasons. Maybe they are together for financial reasons. Maybe they're together for the kids. If a random married person comes into the emergency room, how does the medical staff know which group they fall into? That person who's in one of those three groups that I mentioned probably wouldn't want that information shared with their spouse. They probably wouldn't want their spouse making those medical decisions for them. So in the absence, or in the existence of that, the absence of the power of attorney, medical staffs shouldn't take into account the decisions of the spouse, because it could very well be against what the individual would want, or they'd want someone else making that decision. So the easiest, cleanest way to avoid it is to be proactive and create these powers of attorney. to enable you to give an order of people you want making decisions, decide whether you do or don't. Because, I mean, most married people would want their spouse to make those decisions, but not all.
No.
So
Greater than zero, as you like to say.
greater
right?
than zero. That's exactly right.
We're talking to the Rob Melick Law. If you have a question for us on the air here today, give us a call at 885-4446, or you can send a text, 920-887-9595. I remember when you talk about the HIPAA laws, and I remember when because before it was always kind of a gray area, maybe until about 20 years ago, when there was some Supreme Court rulings about that kind of thing. I remember I was at a Badger post-game press conference.
Sure.
And it used to be, if a player got hurt, I would be like, I got an ankle, and then all of a sudden it became, I could see the smile. I can't remember if it was Coach Bielema or Coach Alvarez. It was like, got a lower extremity injury, and that's all I can say because he cited HIPAA laws. You
bet. Well, and a lot of people ask that, and this kind of ties into sports as well, is like why that information is released in pro sports leagues. Well, I can answer that one for you, right? The leagues, every single major sport league in America, Major League Baseball, NFL, NBA, NHL, they all have what are called collective bargaining agreements, known as CBAs. These are agreements between the players' union and the owners, outlining rights and responsibilities, and every single one of them includes a waiver of HIPAA release so that information can be shared. Now, we all know, Wade, why that information is shared. It's for the gamblers out there, right? So the idea there is that the person, as a condition of being part of the players' union, has waived their HIPAA rights as it relates to the dissemination of the information of that medical. Now, in college, on the other hand, they're not unionized. Now, with NIL nowadays, maybe it's different. I don't know enough about that, but I can tell you certainly when Bielema was a coach and Alvarez were coaches, there was no NIL, right? There was nothing like that. The players didn't unionize. They were student athletes. They were part of this. They weren't getting compensated beyond the terms of their scholarship. So there are HIPAA protections.
Yes.
So that's probably why that happened.
Yep, and then when they rule, and all of a sudden they didn't have to disclose it anymore unless they absolutely wanted to here.
Right.
Rob, if somebody was looking for to get something going on, like say a medical power of attorney, what do they need to do if they need to contact you on that aspect? And then we'll talk about some other options.
Yeah. So whether really anything, whether it's, I know we're talking specifically about powers of attorney, but any estate planning services whatsoever, again, even if it's just to review existing documents, even the review of existing documents at my firm is performed on a complimentary basis. So there would be no charge to just have your documents reviewed. And I give what I call a baseline analysis because I think that's a very important thing for prospective clients to understand. What a baseline analysis is you provide me with your estate planning documents, and I will tell you what I call the story of the estate plan. And what I always tell my client or clients when we're doing that is I'll say, stop me where you don't like what I'm saying, okay? I'm going to go through the story of it. If there's something you don't like, just stop me and say, well, I don't like that, or I don't remember that, or that's changed. And then I note that because then those are things we would need to update in the documents. Because just like anything else, I mean, I'm a big fan of analogies. Think of it if your car is in a car accident. You broadly speaking, you have two options. You can either repair the car or the car is scrapped and you buy a new car. Well, clearly, if you have a $5,000 car and it's going to cost $6,500 to repair it, that would be foolish to repair the car. Just get a new car at that point or cut a check for $5,000. Kind of the same thing with an estate plan. Sometimes estate plans can be amended very easily. Right? You just change a couple things and it would be cheaper than starting over. On the other hand, sometimes the estate plan is in such need of repair that starting over is actually going to be less expensive and more efficient than revising the existing documents. And I give prospective clients that analysis. And again, that analysis is done on a complimentary basis. But again, no matter what you're looking for from an estate planning perspective, I can always be reached by phone or by text at 262-347-3444. Again, 262-347-3444. As I mentioned before, free initial consultation at one of my offices, Beaver Dam, Saukville, West Bend, Germantown. 20% off discount for WBEV listeners. And I do offer night, weekend, and holiday appointments as well. I know some people, work standard 9 to 5s. I don't want people to have to take off work to meet with me, so we can accommodate that. We can meet well after hours during weekends, do everything virtually except for the signing. The signing is the only thing that has to be done in person. But again, my goal is to make this process of at least getting additional information that's personalized to you as quick and as easy as possible. And that's why I offer the appointments in the offices that I do.
You mentioned reviews of people. Maybe they had their documents, and some people maybe had them done in the 70s,
You bet.
maybe the 80s, maybe the 90s. Maybe how often should you take a look at the document that you have and have somebody look at them? I don't know if laws can change in when they're written up, or how often should you review any of the documents that you have?
Yeah, and it's funny you say that because it used to be that about once a month I'd run into an estate plan planning document older than I am, but as I get older, I run into them a lot less frequently. So now it's like once every 3 or 4 months do I come across an estate plan that's older than I am. So I guess that's the disadvantage of getting older, I suppose. But as far as reviewing, I really divide a review into kind of two parts, right? The analysis of, all right, let's take a look at this and see what's changed versus we need to reach out to a lawyer. So I advise every couple years or so just to sit down. If it's a married couple, the two spouses, have a morning coffee, just go over their documents and look over them, again, from a layperson standpoint, not without the involvement of an attorney necessarily, and just say, look, are these documents how we want them organized? Are the people we want making decisions listed as making positions? Are the people or the charities we want receiving the proceeds of our estate still the same? And if they are, great. If they're not, then reach out to your attorney and say what needs to be changed. On the other hand, there could be law changes, as you mentioned. That's my job as the attorney, to let people know of law changes that might impact it. So I always divide these issues into legal sufficiency and preference sufficiency. So legal sufficiency, that's the domain of the lawyer. Reviewing the documents, making sure they're still compliant, making sure they're still legally enforceable, so on and so forth. Preference sufficiency, on the other hand, is 100% on the client. They're going to be the only ones that know what their life circumstances are. They're going to be the only ones who know whether the documents are drafted in a way they want them to be drafted, again, in terms of who has authority and who is going to receive the proceeds of the estate.
Sure. Are there like some things that if you do see older estate plans come in, are there maybe some off the top of your head, like some things that maybe would have been done 20, 30 years ago that can't be done now or is drastically changed?
That's a really good question, Wade. The biggest thing I see there is when I have clients who have existing trusts, they have what are called survivors' trusts and family trusts. And that was done at a time when the federal estate tax exemption was significantly lower than it is now, and Wisconsin did have a state inheritance tax. I believe, and please don't quote me on this, but I believe Wisconsin revoked the state inheritance tax in the early 90s. It was well before I started practicing law, I can tell you that. Early 90s sounds familiar. So it's been a while since Wisconsin's had a state inheritance tax. So obviously if documents were drafted before that, it contemplated a state inheritance tax that no longer exists. But going back to the idea of the survivor and the family trust, the idea was that when spouse one passed away, we would divide assets to the survivor's trust up to the amount of the federal estate tax threshold and then give the rest to the family trust as a means to avoid having to pay federal estate tax. Well, now the federal estate tax for a married couple sits at $25.8 million. I don't have many clients who have net worths of over $25.8 million, so those provisions are largely irrelevant now. Okay. So oftentimes I'll see that and I'll be like, look, here's an easier way to split this up. It was a concern back then. It is not a concern now. Let's revise it that way. Another thing that I will see sometimes is a lot of older documents will not have provisions built in for grandchildren that didn't exist at the time. If I have a couple who did their estate plan in the early 90s, let's say, and they didn't have grandchildren at the time, well, now they're 30 years older and they do have grandchildren, right? I mean, just look at myself. I have two boys who are 15 and 12. In 30 years, I hope I have grandchildren. I hope I have grandchildren a lot less than 30 years, right? Well, clearly I don't have them now. So again, the way I draft my estate plans is that's already contemplated. In other words, the non-existent grandchildren of mine right now are dealt with through my trust, but not every estate planning document has that level of foresight. So making sure that that's updated to reflect those preferences as well.
You mentioned like the $25 million or whatever for like inheritance taxes and things like that. Is there any, if somebody does not have documents laid in place, that are like by somebody like you from Melick Law office, are there financial burdens that could fall on people or the court could rule that, your spouse, whatever, if it's not completely laid out of how some of this stuff is kind of delegated, if something would happen to you?
Yes, and what I would tell you is it's more the simple statement of if you pass away without an estate plan, the state of Wisconsin creates one for you. It doesn't mean the state gets all the money. That's a misconception. A lot of people think, well, if I don't have a trust or a will, the state gets everything. And I want to allay that fear. That's not the case. What is the case is that there are state laws called intestacy laws that determine who receives the proceeds of those estates. So that's what you would have there. The state would determine that. That may not necessarily be who you would want to receive it. I'll give you a common example. Blended families. I mean, blended families are common. 52% of marriages end in divorce. So blended families are very common. Well, what happens, and I had a situation where this came up, where there was an estranged relationship between one spouse and their child. They didn't have estate planning in place. So what ended up happening was the estranged daughter ended up receiving a large share of the estate, even though the spouse didn't want any of that money to go to the estranged daughter. So that happens.
We're talking to Rob Melick. If you have any questions on the air today, give us a call at 885-4446 or send us a text 920-887-9595. So we kind of talked about, if people come to review documents, Rob, what if somebody has no documents right now? And, they're hearing us talking like, I don't want to put that burden on people. When they make that initial contact, though, I guess, what are some of the questions your office will ask to set up for that initial consultation? Will there be any questions except for what time do you need to show up?
I was just say pretty much what time do you want to show up and what office would you like to be at and how would you like the meeting conducted? Because what I do there is I always give just a very broad overview because most people who come to schedule an appointment, certainly not all, but most have some sort of understanding of it. Either they listen to this show, they were referred by a relative or a friend, so they're not coming at it. Some of them are completely blind to it. Some people are just like, I saw your name in Google and, I know I need to get this done. What do I need to do? So, but most people who come to me at least have some idea. So what I always start the meeting out with is, what questions do you have? Are there any specific questions you have? Are there things that I need to be aware of? Because I always tell my clients, while I know the law, I'm not a mind reader. So if there are certain things that are unique or that you have questions about, I want to make sure I address those. But then I always will often say right after that, people don't know what they don't know. So does it make sense for me to give a broad overview of what an estate plan ought to entail? And 98% of people say, yes, do that, please. And that's what I'll do. I'll go over, what powers of attorney are, what they do, why they're important. And then also, probably the most important thing for the majority of my prospective clients is explaining in detail the difference between will-based planning and trust-based planning, making sure they understand the differences and therefore can make an informed decision as to how they would like to proceed. Because to me, that's really the stumbling block for a lot of people. Most people, again, have some baseline knowledge, but when they come to me, they'll say, Rob, can you please explain to me the difference between will-based planning and trust-based planning? We have some friends who have wills, some friends who have trusts. We want to know what's best for us. And again, I walk through the differences. I learn more about their specific circumstances, and I make recommendations. And I try to emphasize that with my clients. Just because I'm a lawyer does not mean that my word is gospel. It's like anything else. You go to a professional gives you his or her opinion. It's from a position of information. It's from a position of knowledge. But at the same time, it's just their recommendation. As the client, you're free to accept or reject any recommendation. But I try to give as much information as I can because what I can tell you is this. It doesn't matter what the venue is. I mean, we're talking about estate planning here, but it could be anything from automobiles to, which generator should I buy to, which snowblower do I want to buy? I mean, anything. You want information. Now, what I will say is the internet there has been a blessing and a curse, right? The internet didn't exist in its form 20, 30 years ago, whatever the case was. People just relied on reputation, word of mouth. Hey, Jimmy, what did you do when you bought your tractor? Things like that. Well, the problem with the internet is, yes, you get some good information, but what I found, particularly with the field of estate planning, is there's a lot of incorrect or incomplete information online. So it's always dangerous to rely upon something you find online. So again, what I recommend is talking to an estate planning attorney of your choice, getting a free initial consultation, learning more about the situation, and then making decisions to what's best for you and your family.
Obviously, it could probably be a full show on trying to decipher if somebody should have a will-based estate plan or a trust-based estate plan.
Yeah.
What is the basic differences between the Cliff Notes version where
Yeah.
people get the full version where they make it a plan?
You bet. Cliff Notes version is this. Will-based planning is not guaranteed to avoid probate. It's really that simple. And there's a lot of misinformation out there from different financial professionals, different people who are tangentially related to estate planning who will say, yeah, put beneficiaries on everything, create a will, it'll avoid probate. That is not guaranteed to avoid probate. It can avoid probate, but it's not guaranteed to avoid probate because any human beneficiary that we list on an asset, whether it's an IRA or a bank account or a life insurance policy, whatever the case is, we cannot state with any degree of certainty whether that person's going to survive. The example I give is this. I'm a father. I have two boys who are 15 and 12. What is the likelihood, and I'm going to have you answer this question, because I know your answer and you're going to be right. What is the likelihood that I survive both of them?
Very slim.
Greater than zero.
Greater than zero.
It
Yes.
goes back to greater than zero,
Yes.
okay? That's the idea. I don't know what the exact number is, and I hope I'm not in that situation. I hope I pass long before my kids do. And statistically speaking, I'm going to be hopefully right most of the time. I don't know what the exact number is, but it's greater than zero. The trust, on the other hand, creates the guarantee because there is a 100% certainty that my trust will survive me. Okay. Can't say that about either of my sons. And the other problem is this: I'm not going to know the answer to that question until the day the second of my wife and I pass away. We will not know for sure whether one or both of our sons survive us until the day the second of the two of us pass away. At that moment in time, and only at that moment in time, will we know the answer to that question. So the trust creates the certain outcome. So again, I walk my clients through that. Now, again, based on statistics, the answer is always greater than zero. But if you take a situation like, let's say, my father's situation. My father is one of 5 sons. My grandmother had 5 boys. Well, the likelihood that 5 children predecease is certainly certainly lower than the likelihood that 1 child, if there's an only child, would predecease. But they're both still greater than 0. And that's what I try to emphasize with my clients, to say, okay, if you want the guaranteed outcome, create the trust. If you want the highly likely outcome, the will-based plan likely will be sufficient. But the consequence of it getting it wrong is that it goes to probate. And that's really what we're looking to avoid here, is probate. And for me, there's really 3 main reasons why we try to avoid probate. The first is cost. Average cost of probate in a state right now in the state of Wisconsin is about $8,000 to $12,000. Second issue is timing. Average length of probate is about 12 to 18 months, and it all becomes public record. You know, most people in this audience have heard of CCAP before. People will use CCAP as a way to vet individuals. For instance, if I'm hiring a babysitter for the night, and I'm going to CCAP that person and make sure that there's no outstanding warrants or previous charges that I don't want to be involved with that, right? So that's what most people use CCAP for, but CCAP just stands for Circuit Court Access Portal. It has information including but not limited to wills and estates that are going through probate and things like that. So again, it's very important to make sure that we at least consider creating a plan that is guaranteed to avoid probate. The $8,000 to $12,000 is going to cost 12 to 18 months that it's going to take, and the fact that it's public record. The trust creates that guarantee.
Rob, somebody may be listening right now and be very, not know a lot about what we're talking about. If you keep using the term probate, can you explain what probate means?
Sure. Probate is the process where a court oversees the administration of an estate. Under Wisconsin law, when an estate goes to probate, there are a series of hearings, a series of filings, a series of deadlines, a series of events that occur before assets go from the name of the deceased to the name of the intended beneficiaries. And again, the goal for most people is to have that be as quick, as easy, and as inexpensive as possible. And probate avoidance through the creation of a trust is the way to do that, because there won't be any probate if it's passing through a trust and the trust is funded properly. That's the other thing I want to emphasize too. Where I do run into some issues is I do have some clients who will say, well, my parents created a trust and it still went to probate. What happened? Well, first of all, without seeing the documents, I don't know, but I can guess, and I'm usually correct with my guess. My guess is that the trust was not funded properly. I'll give you an analogy there. That would be like going out and buying a brand new car. You do your reviews, you find a car that you like, you drive it around, okay? Well, eventually the car is going to run out of gasoline. And when the car runs out of gasoline, it's not going to work anymore. You got to put gasoline back in the car to make it work again. That would be the equivalent of creating a trust and not funding it. Would be, okay, you've done the work of creating the trust, but if you're not funding it, it's not going to work once the individual passes away. So it's important to make sure that we have the trust listed as a beneficiary appropriately for the assets to make sure the trust does what it's supposed to do. Because when I have dug deeper into that, 95% of the time, that's the problem. It was never funded. There was no instructions. The attorney did a great job of creating the trust, but did a lousy job of making sure that the trust had what it was supposed to have.
Talking to Rob Melick from the Melick Law office. Rob, what's your office? If you want to make an appointment at your office as opposed to calling us now, what are the numbers, how they contact you?
You bet. Best way to get a hold of me either by phone or by text is 262-347-3444. Again, 262-347-3444. The text number is open 24/7. As far as phone coverage, we typically have someone answering the phone between 8 and 5. Varies based on days, vacations, sick days, things like that. But generally speaking, someone will be available to answer your call between 8 and 5. I do have offices in Beaver Dam, Saukville, Germantown, and West Bend. Free initial consultation to anybody, but especially WBEV listeners or viewers. And then also 20% discount that would be for WBEV listeners or viewers here. Just mention you heard or saw me on this dailydodge.com or heard me on WBEV. We'll happily take 20% off the bill for you.
What would you say to somebody who says, well, Rob, why can't I just, said the internet's a great thing and it's a bad thing. Why can't I just go find something online where it says fill in the blanks?
Right.
Put my name in, my wife's name
You
in,
bet.
my kid's name in. Why can't I just do that, Rob?
Well, I'll give you an example,
Yeah.
and this is actually pretty funny. I have my new office in Saukville, right? And I got a conference room, and I put up a TV, so I have that way I can show things to clients, and I can watch baseball when I want to watch baseball, right?
Yeah.
And that's what I was doing one day. I had just downloaded the MLB app. I was watching just some spring training stuff, and on MLB Network, and they had an ad for trustandwill.com. Okay, they have Matt Stafford, the quarterback for the Rams, advertising it. And what I wanted to do, and if I ever see it again, I'm going to. I didn't have the remote with me. I was going to pause it because at the end, the disclaimer at the bottom: this is not a substitute for legal advice. See an attorney to make sure this is done. So this is a commercially available product that is telling you in very small print at the end, this is not a substitute for legal advice, because it isn't. It is a draft legal document that may or may not be enforceable, that may or may not do what it's supposed to do. And the argument would be, and I always have this discussion with people when I talk generally about this type of question, there are venues where it's appropriate to save money, right? If I want to get a 12-pack of soda, and I know one store has it for $8.99, another store has it for $5.99, I'm going to go get it for $5.99 because those are exactly the same. A 12-pack of Diet Mountain Dew is exactly the same at one store as it is the other. Legal advice is not the same. You're paying for the service, you're paying for the expertise, you're paying for the knowledge, you're paying for the accessibility of being able to call somebody and say, hey, look, I got a question, I got a problem. You're not getting that through any commercially available website. And the problem is with this service, you're not going to know whether it's effective until you're already deceased, right? I mean, if I buy a snowblower and the snowblower doesn't work, I can say, hey, look, nothing for nothing. The snowblower's not working. What can you do to help me out here? We're not going to know the sufficiency of legal documents until after we've passed away and we don't have any recourse to be able to get it right.
Sure. So again, what's your phone number? People can call to make know that they should feel confident and sleep well at night.
You bet. 262-347-3444. Again, 262-347-3444.
Now, Rob, people will call, like you said, maybe somebody looking for a will. They're looking for a medical power of attorney.
Yep.
Typically, people may come for bits and pieces, but then there also are options to kind of do everything you need to get taken care of. If somebody came to you and said, Rob, I need to make sure my future is completely taken care of.
Yes.
What were the things that they would need to get taken care of to make sure their future and they take the burden off of maybe their loved ones?
Well, definitely powers of attorney. Everyone over the age of 18 should have a medical and financial power of attorney because every single one of us, regardless of age, regardless of health, we're all one moment away from incapacity. So that's kind of the starting point there. The next decision is will versus trust. I always tell my clients there's pros and cons, as we've just pretty much walked through, but you need something. You need to have either a will or a trust in place to make sure that we have all those taken care of. Now, what I will tell you is this. I have some clients who've gone through what I call the evolution of the estate plan. And I'll just walk you through it with a fictitious individual, okay? Someone reaches the age of 18. I have very, very, very few clients who reach the age of 18 who say on their own, you know what? I need powers of attorney. It's their parents who are listening to the show or their parents who are existing clients of mine who say, you know what, Junior's about to turn 18. We need to make sure Junior has these documents. So Junior begrudgingly comes into my office, signs the documents, makes them enforceable. He doesn't care, but his parents now have peace of mind. Okay. Well, what happens? Junior eventually goes off to college, goes off to the military, starts his career, whatever the case is, and then gets married. Junior and Junior's spouse have a child. Well, now they should realize that the only way to determine guardianship under Wisconsin law of children is through a will or a trust. Literally nothing else works. So again, as parents of a minor child, I will tell you that's the most important thing an estate plan can do for me, at least for the next 5.5 years until my youngest turns 18. Now, once my youngest turns 18, it's irrelevant because we don't need to worry about guardianship once they've reached the age of 18. But during that time, that's the most important thing that can be done. So what'll happen then? Well, whatever Junior paid for the powers of attorney back when they signed them gets defrayed off the cost of the will because clearly the will-based plan is going to cost more than those powers of attorney. So now Junior and his spouse sign the will. They now have guardianship of children. Well, now what happens? They have some success. They build a home. They get some equity in the home, and they start hearing about this probate thing. Well, gee, what do we do now? I meet with them again. I say, look, you had the will before. That was great for guardianship purposes, but now you want to have a trust to avoid probate, the cost, the time, the publicity, the aggravation of going through probate. Let's create a trust. Well, what they paid for the will in time 2 now gets deferred off the cost of the trust in time 3. I have what I call built-in credits for that because that type of scenario happens frequently where people go through that, again, the evolution of the estate plan. So I do want to make sure that people, again, I can't promise my clients my rates will stay the same. They probably won't. But what I can tell you is whatever you paid for previous services would get defrayed from the cost of future services. The other thing that I think distinguishes my practice, Wade, is I do not charge for revisions to documents. So if you do initial documents with me, and there are revisions, those changes are done on a complimentary basis. Now, a lot of times people say, well, why would I need to change my documents? I give a couple examples there. One would be if I had my documents right now, I don't have grandchildren. Yes, I contemplate for if one of my children predeceases, their share goes to their children, but maybe I want to leave $1,000 to each of my grandchildren. Well, that's not in there now. That needs to get changed. The other thing is this. I mentioned the two boys, 15 and 12. Right now, because they're minors, they have one role under the estate plan. Beneficiaries. That's it. That's all they can be. Well, once they turn 18 or anything above 18, maybe they're the ones in charge of their own trust. That's very common. I'd say 95% of my clients who have adult children have their adult children in charge of their own trust. Very common. Agents under power of attorney. They're making medical or financial decisions if one parent passes away. We need to update the documents accordingly. What happens if people move? Maybe you have adult children now, and the child you picked to be your primary after the spouse under the financial and the healthcare power of attorney, maybe they get a job they can't refuse in Japan. So now they have to move off to Japan, and we have to change the order of the agents. Those are common events that cause us to want to update the documents, and those changes are done on a complimentary basis at my firm if you did the existing documents with me in the first place.
What would happen if you didn't change it, though, and somebody is in Japan and all of a sudden something happened?
Right.
How would they handle that?
Right. Again, in my documents, I can't speak for every attorney, but it's pretty common. We'll put in language that says if Japan child, we'll call them for purposes of hypothetical, Japan child is unable or unwilling to serve, then it goes to next person. That's why it's always important to have a hierarchy of individuals. But that would require the Japan child to send something to the medical provider to say, look, I'm unavailable. I'm hereby ceding this authority to my sister, whatever the case is. So yes, there would be backup provisions in there. But if you only list junior and junior's unavailable, we got a problem. We're back to not having. We're back to the equivalent of not having documents in the first place at that point.
So typically, if somebody needs to make an initial appointment with you, Rob, at the Melick Law office, it probably depends on time of year. I know you said fall is usually or into the winter months is usually your light time. Like this time of year, somebody looks to get an appointment, call your office, and you kind of find a time.
Yeah,
you're going to be in somebody's area.
Correct. And what it is this for most people in the Beaver Dam listening audience, Beaver Dam is the most convenient location. So Beaver Dam, if you know the geography of Wisconsin, is my farthest away office. So what I try to do is I try to concentrate appointments here. Third Monday of every month, for instance, since I know I do this radio show, I'm busy all day. I've had appointments from 8:30 this morning all the way till 5:30 tonight. Just concentrate those appointments in Beaver Dam. That said, I'm typically in Beaver Dam at least once a week, typically twice a week, even on non-radio show appearances. So we can make that work. I just try to accommodate the days, and I try to, again, be as flexible as I can. I'll ask people, what time of day works best for you? Night, weekend. And sometimes there's emergencies that need to be pushed to the top of the queue. I look at it compared to the medical field. If you're in an emergency room, right, you're in because you have an upset stomach. If someone comes in with a bullet wound, well, they're going to treat the bullet wound person first. They triage the situation, right? No different here. I might have documents, then I'll say, mom and dad are, in hospice, and they only have a couple weeks here. That will get pushed to the front of the queue because that's where it's necessary. I mean, anybody could die tomorrow. I get it. But again, looking at probabilities, the likelihood of somebody passing away earlier, if they have some sort of condition, is greater. So we have to make sure those documents get done.
So if somebody would come into you, let's say they're not pushed to the head of the queue, it's not an emergency situation. They have their initial consultation.
Yes.
And they figure, Rob, we want to do these. We want to do the whole boat.
Sure.
Then is there another meeting where you come with information, or do you bring it with you?
Yeah.
Or what do you need to do next?
Usually it's a 2-meeting process.
Okay.
I mean, no situation's equal, but the general thing is I have a meeting, let's say with the Smiths. I meet with the Smiths. They decide they want to go forward. During that initial meeting, I take down the information that I need to get the documents drafted. Usually takes about 10 to 15 minutes through an intake interview. I get that information. I draft the documents. They come in for a signing. I explain thoroughly, verbally, as well as in writing, if they create a trust, how to fund the trust, if they have a will, how to make sure we have beneficiaries on everything. Because I don't really care about the amount of assets people have. In other words, I give the exact same advice if somebody has $1 in their savings account versus $10 million in their savings account. If they have one account at one bank or they have 6 accounts at 5 banks, it doesn't matter. It's dividing assets into groups. So again, I streamline the process that way by taking not the granular approach of accounting for every single asset, but creating buckets of assets and making sure that all assets that fit into that bucket are appropriately listed as far as beneficiaries.
Sure. And once you have all that information, how long does it usually take your team to get the paperwork drafted out where somebody can have the physical document ready to go?
About a week to a week and a half.
Sure. And then we always ask you the question: once you complete those documents, what should somebody do with those documents?
Yeah, so what I always recommend is making sure that you have them in a secure, identifiable place that's easily accessible. So it doesn't necessarily have to be in a safe or a safety deposit box. They can be if you want them to be, but not everyone has that. What I always tell my clients is make sure they're in a place where your loved ones who are agents can get them. So, for instance, if there's a medical emergency, you let the kids know way ahead of the medical emergency, hey, the estate planning documents are in the third drawer of the bedroom armoire, whatever the case
Even
is.
if you have minor children, they should probably know that, shouldn't they?
I think it's a good idea. Sure. I mean, and again, just even though they're not going to be the ones having authority, maybe they tell their aunt, oh, by the way, mom and dad's estate planning documents are here, just in case the aunt forgets. That can happen. So I do recommend doing that. And then, like I said, at our office at Melick Law, we always keep a copy of all of our clients' documents. So again, that is not a legal requirement. A lot of people get confused by that. A lot of people will say to me, well, my lawyer has a copy. I'm like, don't assume that. Ethically, lawyers are not required to keep copies of documents. In fact, most lawyers don't, particularly older lawyers, right? Because let's just turn back the clock 20 years ago, right? If I'm 17 years into my legal career. Let's say I was 17 years into my legal career 20 years ago, okay? What would I have? I would have boxes on boxes on boxes of estate planning documents.
Like the end of Indiana Jones, Raiders of the Lost Ark, where they go on there and there's a huge warehouse of nothing but
exactly. You'd
files.
have to do that, but at the same time, I didn't come to that time. I'm practicing in 2025 with 17 years of practice. Everything's in the cloud. We have everything in a secure cloud-based system, so I don't have to have boxes on boxes on boxes of documents. So I don't blame the attorneys who were older and who had to do it that way, that they didn't keep documents. But at my firm, because I have that cloud, I can afford my clients and give my clients that peace of mind to say, if you guys do lose or misplace the documents or they're caught in a fire, I had one client say they lost them in a flood a couple years ago. These things happen. We can get you a copy set.
Awesome stuff. Rob, again, if somebody wants to get the ball rolling and make an appointment, again, give us your contact information, where you're located, for initial, even if they have basic questions that they want to ask before they make an appointment, how do they get in contact with you?
Yeah, best way to get a hold of me is by phone or by text, same number, and that's for all my office locations, 262-347-3444. Again, 262-347-3444. Call any time of night or day. I usually have a paralegal answering the phone between 8 and 5. It varies based on sick time, vacation, whatever the case is, but generally 8 to 5. Someone will answer your call. Otherwise, we will return your call right away after that. Offices in Beaver Dam, Saukville, Port Washington. Beaver Dam, Saukville, Germantown, and West Bend are my 4 office locations. I do offer free initial consultation, 20% discount for WBEV listeners, night, weekend, holiday, and virtual appointments as well.
If they're looking for information on the web, you're there as well. And how do you spell Melick?
Yeah, Melick is spelled M as in Mary, E-L-I-C-K. So my website is melicklawwi.com. So MELICKLAWWI.com. Believe it or not, I have a pretty unique last name. I've never met anyone I'm not related to with my same last name, but there is an attorney, Melick, who has already taken the melicklawwi.com domain out in Rhode Island. So that's why I had to add the WI to my website. Always
informative. Again, it's important to get the ball rolling. I know, like I said, I've been kind of going back and forth on when I'm going to get my appointment with you, Rob. And it's going to be happening sooner than later.
You bet.
The next couple of weeks, I think. Thank you so much.
Good seeing you, Wade.
All right, this has been the Melick Law Show on 95.3 WBEV and Daily Dodge TV. Have yourself a great day, everybody.